Hello, I'm Carla Hartley of Hartley Law Group. Through our firm's extensive experience successfully handling numerous adoptions, we've helped many families secure permanent legal relationships. I have a special heart for step-parent adoptions where the biological parent has essentially walked away from this child. Countless couples raise these children with deep love, yet never take the legal step of adoption, believing it's too difficult or impossible. Trust me when I say it is not too difficult and it is not impossible if we have the appropriate facts. And very often, if you've been raising someone else's child, you may well have the appropriate facts. In Texas, when we're looking at an adoption proceeding, we file under Family Code Chapter 162. With consent or proven grounds, this can move efficiently, often with one meaningful final hearing. Pick up the phone. It's worth it to learn whether grounds exist in your case, what challenges may arise, and whether any shortcuts can help you finalize faster. Texas petitions for adoption also include a request to terminate parental rights, either by consent or for cause. Consent uses a strong and irrevocable affidavit of relinquishment. With consent, the hearing may take 20 minutes, 30 at most. Without consent, Texas Family Code Section 161.001 provides clear grounds such as abandonment, failure to support for the required period, endangering conduct or conditions, and more, all while keeping the child's best interests front and center. The proceeding takes place in two phases. Phase 1 is the hearing within the same case number on termination of parental rights. If the termination is granted, Phase 2 is the adoption proceeding itself. In an unconsented adoption proceeding, the bulk of effort and evidence goes into the termination hearing. We've walked many families through this successfully. In Texas, we file under Family Code Chapter 162. Unlike California, Texas does not have a specific statute that automatically allows termination after a set number of years of guardianship, but long-term caregiving by a step-parent or a relative gives us very strong evidence for the standard termination grounds under Family Code Section 161.001, such as abandonment or failure to support. This will also apply if we have a non-relative guardianship that has been in place for the requisite amount of time. We prepare all required forms, coordinate the social study, which is often streamlined when the child already lives with you, and prepare you for a positive court experience. A lot of cases involving termination of parental rights and adoption get hung up on something called the ICWA inquiry. ICWA stands for the Indian Child Welfare Act. The U.S. has treaties with the American Indian nations, and out of those treaties, ICWA, again, the Indian Child Welfare Act, inquiries are mandatory as to the child's potential Native American heritage. Texas legislature has codified the ICWA inquiry, and a crucial part of every case is adequately addressing the Indian Child Welfare Act's requirements. This is federal law, 25 U.S.C. Section 1901 et sec, that applies fully in Texas adoptions, as it does in all states. We carefully inquire about any Native American heritage early on to determine if the child is or may be an Indian child. This step is vitally important in Texas. Proper ICWA compliance respects the law, protects tribal rights, and gives you the greatest confidence that your hard-earned adoption order is final and protected from future challenges. We make sure this is handled correctly every time, including addressing whether the child has American Indian tribal connections prior to filing the petition to terminate parental rights and for adoption. If it turns out the child does have sufficient or substantial Native American heritage, we want to advise you appropriately that you may end up in a contest for that child where the tribe seeks to prevent the termination of parental rights and or prevent the adoption. Now, I want to give you a caveat here. Sufficient American Indian ancestry. It's not, that there was at some point in the distant past Native American who married into the family or had a child who was your great-grandsister. This is something that requires a present Native American ancestry of sufficient percentage to enable that child to belong to a tribe. In discussing whether someone has sufficient Native American ancestry to qualify as giving the tribe a vital interest in their future, it is the percentage, and it does matter. So, for instance, if you have one 1064th Native American ancestry, the tribe has no interest. The tribe has no right or interest in being involved with this child. If the child's a quarter Native American blood, then we have a very different issue because that is sufficient. So again, in Texas, we make this inquiry early and we nail this down before we file anything. Because the last thing we want you to do is to spend a lot of money with us when we could have known in advance that this was not going to be successful. It does, again, I do not want to discourage you because great-great-grandfather was half Cherokee or something like that. If the Native American bloodline percentage is not enough, then the tribe has no right to be involved here. So we avoid all of this problem by looking at this early. Our firm's experience help makes this life-changing step of securing the safety and the stability of a child you love and have been caring for feel manageable and hopeful, and we're good at it. Again, my name is Carla Hartley, and I hope this has been helpful.